our esteemed guest, Professor Grimm, distinguished rector of Bilkent University, Professor Aydoğan, dear guests. It's a great honor for me as a constitutional lawyer to welcome one of the world's most important public intellectuals and public lawyers, namely Professor Dr. Grimm, here at the Bilkent University on the occasion of the 100th anniversary of the Republic of Turkey. It's the first time that it's not the second time, Professor Grimm is visiting Turkey, but the first time Ankara. I do hope that he will leave Ankara with positive experiences and lasting impressions. It would certainly take some time to list all his achievements and services to German constitutional law and public and European law at the international level. There are generations of lawyers all around the world who are loyal followers of Professor Grimm's seminars, roundtable discussions, and public lectures. Thus, I will try only to give an overview of his vita. Dieter Grimm studied law in Frankfurt, Freiburg, and at the Free University in Berlin. And after taking his master's degree from Harvard Law School, he joined the Max Planck Institute for Legal History and Legal Theory as a senior research fellow. In 1979, he was appointed as a professor of public law at the Faculty of Law in Bielefeld, where he met many great intellectual scholars at their time from all disciplines. Among these, one can list the sociologist Niklas Luhmann and the historians Hans-Ulrich Wehler, Jürgen Kocker, and Reinhard Koselleck. Following his appointment as a judge at the German Constitutional Court, he served from 1987 to 1999 in Karlsruhe. After his service, he was appointed as a professor of public law at Humboldt University Berlin, and from 2002 and 2017, he also taught at Yale Law School. From 2001 to 2007, he was also director of the Wissenschaftskolleg zu Berlin, Institute for Advanced Studies in Berlin, and he is still a permanent fellow of this very renowned institution. Professor Grimm holds honorary doctoral degrees from the universities of Toronto, Göttingen, Porto Alegre, Bucharest, and Bielefeld. He is a member of the Berlin Academy of Sciences, the Academia Europaea, the British Academy, and the American Academy of Arts and Sciences. Dieter Grimm unquestionably stands as one of the foremost intellectual figures in the field of public law in the post-war era. He fearlessly engages in public discourse, including spirited debates with scholars such as Jürgen Habermas and constitutional lawyers worldwide. His contributions extend beyond academia, as he actively shapes and leads discussion through influential publications in respected media outlets like the Frankfurter Allgemeine Zeitung in Germany. Dear Professor Grimm, it's a tremendous honor to have you here with us today. And now I would like to invite our esteemed rector, Professor Kürşad Aydoğan, to share some insights into the history of our university and provide an overview of the remarkable Doramaca House, which currently serves as our hosting venue. Thank you very much.
Dear Professor Grimm, dear colleagues, dear guests, I would like to extend our welcome on behalf of Bilkent University to this conference to be given by Professor Grimm, organized by Faculty of Law on the occasion of the centennial of the Turkish Republic. So this year, 2023, marks the 100th year of the establishment or the declaration of Turkish Republic. And I'm glad to say that this is also the centennial for Ankara declared as the capital of Turkey. So that's also something to celebrate as far as me is concerned, because I'm from Ankara. Well, Faculty of Law is organizing this seminar series, and in this particular seminar today, we are hosting Professor Dieter Grimm, a prominent scholar of constitutional law on this topic of the Republic. So, as our dean has mentioned, most of you know our history, but as a reminder, let me again say that Bilkent University was founded by Professor İhsan Doğramacı with the aim of being a center of excellence in research and higher education. So, His long-term objective, however, our founder's long-term objective was to create a non-profit private university to serve the public. So today, this mission, we are trying to keep that mission and try to achieve that mission as a whole university. Now, about this building, well, this is the Doğramacı residence. Well, Filiz Hanım, if I make a mistake, please correct me, okay? Because she has been in close contact with our founder throughout most of his recent life, I guess. So she spent much more time here than any of us did. So this building was completed as residence of the Doğramacı family in 1991. So it occupies 4 hectares of land, and then the building space is 3,200 square meters over 3 floors. So this floor, the ground floor, is the social area where we have this hall, and then a living room and a dining room and a small kitchen. So most of the social activities were done here. So downstairs we have a similar functioning place. We have a lecture place and a video room where we have some images and then short videos of people who say certain things about our founder. And then upstairs is the private quarters where they spent most of their life. So when this building, and the architect is Erkut Şahinbaş. When this building was completed in 1991, of course it belonged to the Doğramacı family, but our founder has transferred the ownership of this building to İhsan Doğramacı Foundation, with the condition that they would continue to live here until they pass away. So he and his wife lived there, and İhsan Doğramacı passed away in 2010. Then his wife passed away later on in 2018, I guess. And then the ownership is transferred to the Doğramacı Foundation. And at that point, the foundation has signed a memorandum of understanding with Bilkent University to use this building as a venue for social, artistic, scientific, and cultural activities. And the name of this building is declared as İhsan and Ayser Doğramacı Social, Cultural, and Artistic Center. So we have gathered here a few times for social. By the way, the building was restored with all the artifacts in it, the paintings, the china, their personal belongings, the furniture. And then we had some social gatherings here, but I think this is the first event, first conference that we are having here in this building, in line with the motto of the objective of this building. So that's another occasion to celebrate. So I would like to thank the Faculty of Law for putting together this activity on the centennial of the Republic, and I would like to thank all of you for coming here. Thank you.
Dear Rector of the University, dear Dean Götz-Tepe, ladies and gentlemen, first of all, I would of course express my gratitude for being invited to this occasion, and as I hear now, to be the first speaker in a conference going on in this venue. I'll keep that in mind, because it is not only a pleasure for me to speak in such a room and before such an audience, but it's also an honor for me. Now, to the subject of this evening. After hundreds of years of monarchical rule, our two countries, Turkey and Germany, became a republic in the wake of World War I. The two constitutions, the Weimar Constitution of Germany of 1919 and the Turkish Constitution of 1924, begin with the same sentence, only in different languages. Article 1, Weimar Constitution of 1919, das Deutsche Reich ist eine Republik, the German Empire is a republic. Article 1 of the Turkish Constitution, the Turkish state is a republic. For both countries, I think this transition was a very deep break in history, given the long tradition of another type of political structure and another type of rule. For Turkey, I think that the break was even bigger than it was for Germany. Germany was in 1919 already a modern state with a functionally specified system for making political decisions, with a professional bureaucracy, with an independent judiciary, distinguishing politics from religion, to say a secular state. The era of constitutionalism had begun in Germany already in the early 19th century. In the various states, there was no unified Germany at that time, and the first attempt to create an all-German constitution dated back to 1848. It failed, as the whole revolution of 1848 failed in almost every country. It was a common European event, with only leaving the Iberian half peninsula out. But had it been successful, had the revolution of 1848 been successful, Germany had already been a democracy 70 years before the Weimar Republic. So the democratic state was already envisaged in Germany in the 19th century. Democracy was present as a postulate. However, the failure of democracy, of a democratic constitution, did not mean a return to the absolute monarchy. German states already in the early 19th century were constitutional monarchies, and so was the German Empire, the first German nation state of 1871. There was already a civil society as well in Germany. The medieval structure, the feudalism, was abolished early in the 19th century. There's some beasts running around here, sorry. The legal order was gradually transformed from a legal order based on objective duties to a legal order based on subjective rights. The individuals were no longer subjects of an absolute ruler, but citizens. Universal suffrage existed, although only limited to men. Fundamental rights protected the individual against intrusions in their liberty by the state. The market economy was fully developed. Germany was a highly industrialized country. Consequently, all this that I mentioned up to now was in Germany not combined with the notion of republic. It existed before the republic, and it existed independently of the republic. What came together with republic in Germany was democracy. The next sentence in the same article, after the sentence that I read, the German Empire is a... I didn't get it, I'm sorry. So, after the first sentence of Article 1, the next sentence is public power emanates from the people. So this is the central provision of a democratic state. Democracy was then concretized as representative democracy, with the parliament in the center, and with parliamentary elections, and with parliament in the center and parliamentary elections, inevitably political parties arrive. Political parties were not new. The German party system had formed in the revolution of 1848, but there is a difference between a party system in a constitutional monarchy or in a democracy. In the democracy, as opposed to monarchy, parties played the decisive role. In the representative democracy, parliament was composed of parties, and the victorious parties formed the government. For Turkey, more or less, if I am correct, all this that in Germany emerged over a period of, let's say, 70 to 100 years, came at once in 1923. A revolution from above, not like in France, a revolution from the bottom, not like in Germany, a mixture of modernization from above and fights for modernization from the bottom. This had consequences for the notion of republic. Legally speaking, republic was in both countries, my own country and your country, a rejection of the monarchy or of monarchical structures of rule. So it's to say it had primarily a negative meaning. It did not say what shall be, but it said what ought not to be. However, around this narrow notion entwined some positive content, not identical with or part of republic, but associated with republic. In Germany, as I said, it was democracy that went along with republic, and in Turkey, I presume, it was the whole project of modernization. Now, constitutions are not internally enforced, even if they contain an eternity clause, like the German constitution does. The eternity clause of a constitution exists only as long as the constitution exists. Turkey has had several constitutions between 1924 and today, but the belief in republic remained upheld by the Republican Alliance, and only today, if I see that correctly, you know it better than I, some elements that originally were regarded as achievements may be no longer regarded as achievements. German history was complicated in a very different way. In the course of the revolt at the end of World War I, all German monarchs abdicated. The emperor fled to the Netherlands. Monarchy was no longer an option after this event. The election to the National Assembly that was supposed to draft the new constitution, Weimar Constitution, the election brought a tremendous victory for those political parties who had been in the opposition in the empire and now had a vast majority in the assembly of 1919. 76% of the population had voted for those parties who were in favor of democracy. The Social Democrats, the Catholic Party, Centrum, and the Left Liberal Party. Together, I mentioned it, 76%, and the Weimar Constitution was adopted with the same majority, 76%. However, already the first election to the parliament, 1 year later, 1920, brought a defeat for these democratic political parties. They lost their majority. Together, they never had a majority, not even an absolute, a simple majority, and they never regained it during the whole course of the Weimar Republic. This had, of course, several reasons, but I think the most important reason was the peace treaty of Versailles, so to say, the parallel to the Sèvres Treaty for Turkey, which was concluded a few months after the Treaty of Versailles for Germany. The Treaty of Versailles for Germany was extremely hard and humiliating, and many voters who in January 1919, when the National Assembly that drafted the Constitution was elected, had voted for the democratic parties, had voted for them for motives, not that they were convinced of the superior quality of a democracy, but they had voted for the democratic parties because they expected that if Germany turned to democracy, the conditions, the peace conditions would be mild. And this expectation the reward, so to say, for voting for democratic parties never arrived. And so for many, the reason for voting democratically had become obsolete. The Democrats were now made responsible for this harsh treaty. They shouldn't have signed it, as one said, but there was usually no alternative. But they were made responsible for something that had been caused by the empire and not by the democratic forces. So there were many discontents about the democratic republican order. Many who wanted back behind the Weimar Republic, back to monarchy, or at least to an authoritarian system. And there were others who wanted to go forward to a more Soviet-like Rätesystem. What is that? Council, Soviet council art system. In addition, the Weimar Republic in the 14 years of its existence almost always suffered from economic crisis, and it suffered politically from a failure of the parliamentary system. There were always many parties in parliament, and most of them were ideological parties, and ideological parties may mean at the same time that finding compromises is more difficult than when you have interest parties, that you can have a back and forth, give and take, but as soon as you have ideological parties, all this becomes much more difficult. So an instability, governments that lasted for 14 days, and the longest government was a government for 2 years. And toward the end of the Weimar Republic, the radical parties on the left, communists, and the radical party on the right, the Nazi party, together held an absolute majority. That's to say, they could bring every government down, but they were not able to form a new government. So the system was finally completely paralyzed, and this was the situation when Hitler was called to power. After the Nazi period, after World War II, there was in the current constitution of Germany, the basic law, there was no equivalent for Article 1 of the Weimar Constitution. The current German constitution's Article 1 says human dignity is inviolable. So it didn't start with the principles for the state, but it started from a basic value of individualism. A republic appeared only in the name of the new state, Federal Republic, and there was a discussion in the Parliamentary Council who drafted the basic law whether one should mention republic, and then people said we cannot say that the Federal Republic is a republic, it doesn't make any sense. So it remains with Federal Republic, but Republic appears in Article 28. This is an article that guarantees homogeneity between the state constitutions and the federal constitution. Germany is a federal state, and each state has its own constitution, so there must be a certain homogeneity, and this is what Article 28 guarantees. The article reads, the constitutional order of the Länder must conform to the principles of a republican, democratic, and social state government governed by the rule of law. So here republic appears as an individual principle for the republic. So Germany is a republic now. It has remained, of course, a republic after unification. But since there is nobody today who would favor a monarchy, a return to the monarchy, the notion republican has, so to say, lost its enemies or has lost its opponents. And this means at the same time that the notion republic in the constitution is without regulating substance. It's not obsolete, of course, if there should be again a monarchical movement, there is nothing like that, but if there should, then of course the article would have a meaning. But since there is nobody, to my knowledge, at least no group that is visible, that would favor monarchy, the notion republic has no actual impact. And this can be seen at various places. It can be seen, for instance, in the jurisprudence of the Federal Constitutional Court. Republic does not play a role. I looked through the index. And I looked through the volumes that name the even minor notions that play a role in the jurisprudence of the Constitutional Court, and Republic is just absent. You can see it in the legal science. Almost all commentators of the Basic Law say Republic exhausts itself in the negation of a monarchy, and since there is none who advocates a return of the monarchy, it is an empty clause, so to say. There is I would say, less than a handful of constitutional law professors in Germany who try to enhance the status of republic. They say this is really the key notion. We would all probably say dignity is the key notion from which you develop all the rest. There are a handful, less than a handful of professors who say republic should be the key notion of the constitutional order from where all the other notions should be understood. But the majority, the vast majority of constitutional law professors warns because republicanism or republic so understood could open the doors for all sorts of assumptions and desires that find no basis in the Constitution. So the general understanding is we should stick to what is in the Basic Law and has much more, if not always clear, meaning democracy, rule of law, social state, federal state, free democratic order, which is the basis for the exclusion of parties who would like to overthrow the government, but not republicanism. And it would be interesting, I had a brief look into the book that Dean Götz-Tepe published with a German colleague about the Turkish Constitutional Court, and I didn't find republic. I didn't go through the whole book to find republic, but I looked to the index and I filed a little bit and I didn't find it either. But you will probably correct me if I'm not right with what I say. Yes. So this was, so to say, the first part of what I have to say about the notion of republic in the current German situation, and but I wouldn't like to end my lecture here. You say this was worth coming, but if it is true that republic is of little importance today in terms of constitutional law, that does not mean, of course, that it is unimportant at all. There is rather a growing interest in republic and republicanism in constitutional theory. And so I think I would like to devote the second part of my lecture to these writings, where a republic is in the center of the discussion. Via the salience in constitutional theory, this may, of course, gain over time influence on constitutional law by way of interpretation. These new ideas about republicanism and republic that I want to report about are not so much found in Germany, not so much in other European states, but they emerged mainly from the Anglo-Saxon legal and political science, sometimes also philosophical world. But before turning to the literature that I have in mind, I would like to mention that there is hardly a notion which covers so many different meanings like republic. The history of the term republic begins with Cicero in classical Rome, res publica, those matters that concern all, Gemeinwesen in German language. But one cannot hope that there is a common understanding that over time has prevailed, even to show you how vast the opportunities are under the rubric republic. Even the widely consented opposition of republic and monarchy republic is the opposite of the monarchy is not uncontested. A monarchy can be a republic, namely, if the monarch is not a dictator or an arbitrary ruler. And in the United Kingdom, you will frequently find saying, our republican monarchy. Wolfgang Mager, former colleague of mine at the University of Bielefeld, who wrote the entry Republic in the famous, you mentioned Koselleck Dictionary of Fundamental Historical Notions, needs more than 100 pages, so almost a book in itself, to describe the meaning of republic, what was understood as republic at certain times, in certain countries, under certain conditions. So I will not even make an attempt to summarize these meanings or to find a common denominator. I rather turn to these authors who like to revitalize republicanism as a notion today, and for whom this is the basis of defining the terms constitution and constitutional adjudication. Although they are all also far from being unanimous about what republicanism means, here I think we can decipher, we can identify a common denominator, namely this is a critique, the critique of liberalism. All these people who put their writings of state and political philosophy or constitutional theory under the rubric of republicanism are opponents of liberalism. Liberalism not so much regarded as economic liberalism, but liberalism in the political sense. So the center, of course, of liberalism in the political sense is liberty, yet liberty understood as a freedom of individuals to pursue their own interests, to seek and find self-fulfillment without being impeded by the state. Hence a private liberty, not a public liberty, and a negative liberty that obliges the state to refrain from certain actions. The state is rather reduced to the function of protecting individual liberty against aggressors and against perpetrators. This is done mainly in public law and criminal law, and to coordinate the various liberties, which is mainly done in private law. For the Republican authors, to the contrary, freedom is essentially a public freedom and a positive freedom, a freedom of every individual to act as a citizen, not as a bourgeois, a freedom to participate in the formation of the public will. Parliament is the place where the public will is negotiated in a deliberative manner, and the outcome of these discussions in Parliament is just, not so much because fundamental rights limit the government, but because procedural rules exist that guarantee equal participation and free deliberation. So this is a very different understanding, although the terms are the same, of the main leading principles of the political process. From these premises, consequences are drawn for constitutionalism and for constitutional adjudication, judicial review. Regarding the Constitution, constitutions for these authors should abstain from substantive norms. Nothing that is substance or content belongs into a constitution because it has a depoliticizing effect. What is regulated, liberties that regulate fundamental values, gave liberty, depoliticize these sections and are no longer a matter of public discourse and public decision-making. Constitutions should not constrain government, but constitutions should enable the democratic process. Against the traditional understanding of constitutionalism, the constitutionalism that they mean is very often called by them popular constitutionalism or even populist constitutionalism. nothing to do with what we nowadays understand, what we in Europe understand, or also in other countries under populism, to say populist parties and populist regimes as we see now emerging in many parts of the world. Rather, constitutionalism, where the constitution is not only attributed to the people as the source of all public power, but where the constitution, as they like to say, remains in the hands of the people. It is the people themselves is an iconic term in the United States, the people themselves determine about the meaning of the constitution. If one reads this, one would of course expect that the consequences are a call for more direct democracy. Referenda, plebiscites, initiatives and decisions about constitutional amendments given to the people, which is not the case in the USA. In the USA, the people is restricted to the elections. Many state constitutions of the United States have elements of direct democracy, but on the United States level it is inexistent, so one would expect if the constitution remains in the hands of the state and the people, and the people decides, more elements of plebiscite democracy. But nothing like that, to one's surprise. What is meant is perhaps best expressed in the title of a book by Mark Tushnet, professor of Harvard Law School of Constitutional Law. Title of the book is Taking the Constitution Away from the Courts. They are the target of this new republicanist movement. The Republican understanding of constitutions requires that in conflicts about the meaning of a constitution, not unelected and unaccountable judges decide, but the people themselves. And then comes an important addition, through the regular democratic process. The regular democratic process is of course not in the hands of the people, but in the hands of political parties, of parliament, of government, who elect the people only insofar as they elect these organs. The election remains the only opportunity for the people to express their will. The people do not gain a single additional power in the theories of the Republicanists. The winner is the parliament, the loser is the constitutional court. Republican constitutionalists are deeply hostile against constitutional court and against judicial review. Tushnet, whom I mentioned by name, is by no means alone. It's a number of people, and not in marginalized law schools, but in the best law schools of the country, but not a majority of American constitutionalists. Not people that one can neglect, but they certainly express a feeling or a hope that is widespread. I should add that these books that I have in mind, or articles, were not written after Trump. They were all written before Trump and before the ultra-conservative Supreme Court in the United States that we have now. Before Trump had all reassured their readers that they do not write against a specific court or a specific composition of the court, but that they write from a principled position against judicial review as such, in the name of democracy. Democracy only exists only if the last word in constitutional matters does not lie by the judges, but by the politicians, who can be held accountable by the people in the election. This is the bridge to the democratic principle. When the position is concretized or exemplified, always the substantive provisions of the Constitution are those, I mentioned it, which should be taken out. They should not only not be in the Constitution, but they should not be object of the judiciary. Organizational norms of the Constitution and procedural norms are usually not mentioned. The bone of contention is the jurisdiction in matters of fundamental rights. To be sure, again, they are not against fundamental rights as such. Most authors insist that it is of immense importance for a country that liberty reigns and that individuals have fundamental rights that the state respects, but they should not be enforceable by courts. Taschnet explicitly says fundamental rights should be downgraded to the level of ordinary law. And that means, of course, not longer binding the legislature. The authors differ in degree of the consequences that they derive from their premises. There are those who say that is the mildest consequence, so to say. There are those who say that the courts should only rule about democratic rights. That's to say, when questions come up about right to election, freedom of press, freedom of association, you could find that also with Habermas, for instance. Then there are others who say that every branch of the government decides independently about the meaning of a constitution in cases of conflict. So what the courts say is only what the Supreme Court says or the Constitutional Court says is only binding for the lower courts. It's not binding for the President of the United States. It's not binding for Congress. Departmentalism is the technical term for this. Then there are others who say the courts may decide even about questions of fundamental rights, but these decisions can be overridden by Parliament. Parliament can say, I heard it, but I don't like it, or I don't follow. And they rely for this on the example of Canada. In Canada, as a matter of fact, this possibility that Parliament overrides decisions of the Supreme Court exists, but this came out of a specific situation in Canada. The Canadian Constitution from the 19th century did not contain a Bill of Rights, but Canada felt more and more the necessity of having a Bill of Rights, and finally a decision was ripe in 1982, but to some provinces, especially Quebec, the French-speaking province, was against adopting a Bill of Rights because they said this will have a unifying effect. This will lower the importance of the states. So the only way to get the Bill of Rights of 1982 through was to concede that Parliament may override a decision of the Supreme Court. Now what happened is that it did not happen. There is no case where the Canadian Parliament did it, and there are 2 or 3 cases where Parliament of the provinces did it. But imagine you have the override in, let's say, in Hungary or Poland or other countries. I don't know that they would necessarily behave like the Canadians behaved. So then, again, another consequences, decisions in matters of constitutional law are not binding at all. They are just a sort of admonition. Those who are the addressees of the decision should take that into account and should say there may be good ideas behind it, but they are not binding, regardless of how good or important I may say not. And then probably the sharpest consequence is abolish constitutional adjudication, abolish judicial review at all, which means, talking in terms of the United States, the US Supreme Court decides only questions of ordinary law, criminal law, administrative law, civil law, etc., but no longer questions of constitutional law. This sort of republicanism also means then that all political questions should be decided in the political process and should not be subject to judicial review. That is, they should be decided by the acting majority. Anti-majoritarian institutions like constitutional courts, are incompatible with the republic understanding of democracy. The result of the democratic process should not be counteracted in the legal process. This presupposes, of course, an immense trust in the parliamentary process and in the power of elections. And as a matter of fact, one finds in these books that the shortcomings of representative democracy, the shortcomings of political parties, the low representativity of many parliaments, the distortion of politics through money, the limited meaningfulness of elections, the disproportion of representation of interests, we find that they are all played down. They are mentioned but not taken as serious enough to be a counterweight against the threat to democracy through courts. Now, the main question, however, is, for me, what it means for constitutions if judicial review is not binding or is abolished at all. That's to say, in cases of doubt or in cases of conflicts about the meaning of the Constitution, the majority opinion will always prevail. And this is, of course, of highest relevance for fundamental rights. The organizational structure as laid down in a Constitution will usually be followed. Procedural rules, I would say, also more or less. But this is different with regard to fundamental rights. We have enough historical experience that fundamental rights without judicial review were legally mostly unimportant. This is true for Europe. In the whole 19th century, in spite of the salience of the French Declaration of Rights and the Bill of Rights in all these constitutions that were made, fundamental rights legally played no role. It was true mainly throughout the first half of the 20th century and in many countries even in the second half of the 20th century. I always remember in this context an invitation to Belgium in the 1970s, and my host asked me, invited me to dinner the evening before the lecture, and he said, "How do you plan? What do you plan to say?" And I said, I think I start with fundamental rights. And he said, "Forget it, they are totally unimportant." Belgium had no constitutional court at that time. Now it has a constitutional court, and my host, if he's still alive, what I don't know, would probably no longer say, could certainly no longer say, they are totally irrelevant. But if the Constitution is no longer judicially be interpreted and understood and decided, I think the function of the Constitution as a common basis of otherwise controversial forces is endangered. The peacekeeping, peace-maintaining value is reduced. That depends on the possibility of impartially determining the meaning of a Constitution. Now, again, I don't want to say that a political system or a state without judicial review is necessarily undemocratic or illiberal. We have examples of states without a constitutional court of whom we can say they are good, reliable democracies and liberal countries. But in these cases, the liberal values must have democratic and liberal values must have another basis. That's to say, they must be culturally deeply rooted into a society so that politicians respect them, even if they are not justiciable, either because the politicians are part of this society, or it is for politicians too costly to disregard them because the reaction from the side of the public will be counterweight. But we know from experience that these countries that are democratic and liberal countries without judicial review are very few countries, usually without a functioning constitutional court. You can have constitutional courts that are irrelevant as well, but without a functional constitutional courts, violations of the Constitution remain without consequences for the violator. Elections alone, I think, are no sufficient safeguard. It's extremely rare. You remember the people themselves shall have the say in conflicts. And as it turns out, the only remedy that people have is the election. It's extremely rare that the outcome of elections is determined by a single constitutional issue. Elections are highly generalized judgments about past performances of a government or highly generalized expressions of confidence in a future government. Even more important is the question what remains of the Constitution if this understanding of republicanism would assert itself. The constitutions would perhaps continue to structure the political process through the organizational norms, but they lose their binding force for the outcome of the political process. Its normativity is at risk. As Mark Tushnet, again I quote him out of Menes, explicitly says, constitutions do not regulate the political process, they set the terms for debate about constitutional matters. For me, this is the more irritating, since these theorists of republicanism, well, in their majority US Americans, sacrifice the three seminal achievements that the American Revolution brought, on which the American Revolution stands. First, the assumptions that sovereignty belongs to the people. No organ of the people, no branch of government is sovereign, like in England, UK, up to now, Parliament is sovereign and fundamental rights are below. No organ is sovereign. The right to rule of the organs is delegated by the people. Secondly, in constitutions, the people determine the conditions under which the power may be used. And only if constitutions are binding, have a binding effect, if they do that, they have the capacity. They do it because of the capacity as law. To be more precise, the capacity of being higher law. This is best seen with regard to fundamental rights. In England, fundamental rights exist. First country that had fundamental rights, but they were not constitutionalized. That's to say they didn't bind Parliament. The Americans drew the consequences, fundamental rights binding for Parliament. And the third one is there is no binding effect without teeth, so to say. There is no binding effect if it's not enforceable. And this enforcement mechanism that emanated from the United States is judicial review. In the end, I think the result of these ideas of the new republicanism is a non-legal normativity. It's not no normativity, it's without a legal normativity. And it's taken to the extreme by a Republican movement, now not in the US, but in the United Kingdom, in whose understanding constitutions should no longer be regarded as law at all. This is perhaps understandable for the UK because the UK has never developed up to now a constitution in the modern normative sense, but a mixture that is difficult to define. So it's understandable that the idea comes from here, but it is expressed in very determined ways. The constitution should not be a law because the legal constitution undermines democracy. Legal constitution is the biggest error that was committed for some of these authors, and they would like to reform it. True constitutionalism is not legal, but political. The protagonist, I mentioned Tushnet several times as protagonist for the United States, although he's not alone. The protagonist for this UK tradition is Richard Bellamy, also not alone, but he is the most prominent author. The political process should not be regulated by legal norms at all. The decisive sentence in his book, book is called Political Constitutionalism, is, according to this political concept, I add, of constitutions, the democratic process is the constitution. Is emphasized. The democratic process is the constitution. That's, if a constitution, the constitution is a process, it can of course no longer regulate the process. And the constitution, so to say, is liquefied or is dissolved in what is going on in fact. And so explicitly, another UK author and protagonist of political constitutionalism, John Griffith, the constitution is no more and no less than what happens. So to come to an end, the only remedy in the eyes of these authors, the only remedy for bad politics is the election. But this form of republicanism cannot even guarantee that elections are free and that the result of election matters. I can imagine that there are politicians with this form of constitutionalism, who would welcome this form of constitutionalism. I think someone who regards legal constitutionalism and judicial review as important achievement, as important civilizing factors of countries, they can certainly not. Thank you very much.